Good morning, everybody. You guys have coffee? So one of my biggest fears when speaking in public is not to fall. So I'm going to try really hard not to fall in front of you guys. So, just a quick question, just to know where we're at and who's here. First of all, raise your hand if you're an interpreter. Oh, good. I'm in the right place. Excellent. So, how many of you are court interpreters that are actually work in court as employees? Wow. How many of you are independent interpreters? Quite a few. Excellent. How many interpret primarily in criminal? How about primarily in civil? Both? Nice. Northern California interpreters? Oh, I got a full room. And Southern California interpreters? How about, okay, here's a very, very good question. How about from the Central Valley? Come on, raise those hands. Right there. Excellent. So, the language access plan is an ongoing project. It's been going on for quite a while. I'm very thrilled to actually be privileged to be on it. In fact, I'm actually very humbled to be among so much talent in this room, which is great. And this is something that is ongoing, and Kevin is going to give us a little bit of a background so you guys can understand how this came to be. And then we're going to go into the different goals of the Language Access Fund. Now, the Language Access Fund is composed of 8 goals. And within those goals, there's many recommendations. There's up to, which totals about 75 recommendations total in the Language Access Fund. I believe there should be some documents, packets going out. Is everybody getting them? Yes. Great. That way you guys can follow along. That basically sums up the Language Access Plan, and we'll be trying to go through it as thoroughly as we can. We can't touch upon every recommendation, so we're going to try our best to touch on the most important ones. And if you guys have questions, great. If you guys don't have questions, if you guys have questions afterwards, I will be around, and some of the other panel members will be here too. Okay, so with that, without further ado, I give it to Kevin.
Good morning. So let me just begin by thanking you for the invitation. It is a great, it's a great privilege to be with you this morning. I'm not going to go into a long exegesis here about sort of how we got here. Just as Cuellar had that great quote about experience being the oracle of truth, and there's far more experience in this room than that is going to provide that truth than I could ever get to. But sorry, I have to put this like right in front of my, yeah? Oh, God. I can't use my courtroom voice anymore. So in any event, because of the great experience here, you guys probably know better than I do. My involvement in this issue goes back about 15 years or so when I started working with the legislature, as Mary Lou was indicating. There was a family law interpreter pilot that you probably remember in the late 90s. But when I started getting involved in this a few years later, there had been a period of relative quiet, I think. The issue seems to have sort of dropped off the table. The California Commission on Access to Justice had issued a couple of reports that I dusted off when I started looking at this issue because, frankly, I was flabbergasted that this was not already happening. Because it seems to me, as has already been recited here, that this is as fundamental to the justice system as judges and clerks and bailiffs and everything else. It just seems to me that the system couldn't possibly function without professional court interpreters. And I was really quite stunned to find that that wasn't already the case. And so with Assemblymember Jones, who was then the chair of the Assembly Judiciary Committee, now the Insurance Commissioner, and an announced candidate for Attorney General, actually, we began a series of bills that unfortunately were twice vetoed by Governor Schwarzenegger and once failed in the legislative process because of financial issues. But what we had proposed to do was to start a civil interpreter pilot to begin to experiment with how to roll out this, the expansion of interpreter services in a thoughtful way. And I was very pleased to partner with CFI and with the legal aid community, which really have been drivers in this area. You know, the facts that Justice Cuellar cited regarding the need and the value of these services and the diversity of California were just as true 15 years ago as they are now, right? Unfortunately, it's taken us a while to get there. And I'm sorry to say that we haven't always had the enthusiastic support of the courts in the way that we have from other stakeholders in the process, but I think that that's now changing. And you know, it's a great testament that Justice Cuellar was here. The Chief Justice, I think, has shown that she also believes that this is something that needs to happen. And you know, frankly, I think that it's the involvement of the Federal Department of Justice as the result of the complaint that was filed by the Legal Aid Foundation of Los Angeles, Joann's organization, that really has been very much a catalyst in the recent efforts. Because after the legislation that we did for the last time in 2009, there was really not a lot of activity until the LAFLA complaint and the Federal Department of Justice got involved. But I think now that the court system is getting to where you guys have been for a long time. They now understand, I think, the need for this function and the central importance, the fundamental role that interpreter services have to play in the administration of justice. I will let Joann talk a little bit about what's been happening more internally to get us to this point, but I have to say I'm thrilled to be here, and it wouldn't be here without you guys, so thank you very much.
Hello, good morning, everyone. I'm also very honored to be here to tell you a little bit about the Language Access Plan. And just picking up where Kevin left off, Justice Cuellar did mention this, but in 2013, in June, that's when the Joint Working Group for California's Language Access Plan was established, which Janet was on. It was announced shortly after the DOJ actually issued a letter of recommendation stating that they felt that the California courts were out of compliance with Title VI, and they offered a number of recommendations and requested that the courts fall into voluntary compliance. And so, in addition to a number of different forces at that time, shortly after that was when the Joint Working Group was created to draft the strategic plan for language access in the California courts. And shortly after that, in December of 2013, there were a couple of listening sessions where many different communities, interpreters, legal services advocates, community groups were invited to listen in on what the plans were moving forward from then. And then, I'm sure you all know, in 2014, there were a number of public hearings throughout the state, and the draft Strategic Language Access Plan was issued in August 2014 and opened up for public comment. And I know many of you, as well as many of us, submitted extensive public comments to this in September, and there was a revised draft issued, which was officially adopted by the Judicial Council in January 2015 of this year. And I think you all know, and Kevin maybe could talk a little bit more about this later, but there was also legislation that Kevin worked very hard on that sort of paralleled this to pave the way for some of the new provisions allowing for the prioritization of civil matters if there isn't enough funding. And I believe you have a handout that summarizes Evidence Code 756, which is the new provision that has 8 categories of civil matters that should be prioritized in the expansion, as well as a few government code sections that talk about interpreters, swearing in their credentials on the record, provisional qualification of interpreters, as well as just sort of a declaration and a finding that court should be providing interpreters to all parties who require one. And so with that background, we're going to go ahead and dive into the language access plan. So we could go to the next slide, and you'll see there are 8 goals and 75 recommendations. And the handout that you have, I believe it's 17 pages long. It lists all of the goals and the recommendations under each goal. And we're just going to highlight some of them for you. And as Janet mentioned, we are going to have a period of question and answer at the end. But if you have something, a burning question that can't wait, feel free to raise your hand and we'll try to address them as we go. So I'm going to hand it off to Kevin for goal 1.
Okay, this is easy, and we don't need to spend a lot of time on this, but this is one of those duh kind of no-brainers, right? And I have to say, when I started getting involved in this issue, my very first question is, well, what's the need? What's the demand for court interpreters? What's the LEP population that we're dealing with? And everybody just kind of shrugged, right? So the very first thing that is outlined in the goal 1, is simply to identify language access need for each LEP court user. And also to document that so that, and track it throughout the system, throughout the life of the case, so that the courts are prepared to provide language services when they are needed. Another important part of that goal is also to inform court users about the availability of language access service at the earliest point of their court users' involvement in the system. And to let them know that court interpreter services are not to be provided for a fee, right? I mean, some of you may know that has been a practice in some areas. I think I'm going to go out on a limb and say that's clearly illegal. And I've said that to the courts for many years. I think they're now hopefully finally understanding, but I still think that there are places in the court system now where there are signs up saying essentially that it is not the policy of the court to provide language access services. So change is starting to happen, but this very first goal is to make sure that people are identified and that they are told about the need or the availability of language services. Goal 2 is where the meat of this thing is, and Joann will talk about that.
Okay, so we could go to the slide for goal 2. And it is one of the major goals. When you think about language access in the courts, you think about language access in judicial proceedings, right? So that's what goal 2 talks about, providing qualified language access services in all judicial proceedings. And this goal is actually divided up into 4 parts. So I'm going to cover the first 2, and Janet's going to cover the last 2. But the first part talks about the proceedings themselves. When you think about, you go in the courtroom, there's a judge, there's parties, the proceedings themselves, there must be qualified interpreters provided in all proceedings, including civil proceedings, as prioritized by Evidence Code 756, so you have that as a handout, including family court services mediation. And this has to be done by 2017. So that was a big push that we made because the timeline of this thing is in 3 phases. And maybe I should go over the phases with you really quickly. Phase 1, and after each goal you'll see by which phase it needs to be completed. So phase 1 is 2015, phase 2 is 2016 to 2017, and then phase 3 is by 2020. So the timeline, the goal is everything by 2020, but we really pushed for this, which I think originally one of the drafts was through phase 3, and we really wanted this to be much earlier than that. So in all court proceedings by 2017, and I think one of the things that we're looking at here is, are the courts systematically expanding according to the priorities? I'm from Los Angeles, just as Cuellar mentioned. We have been, the courts in Los Angeles have been putting out announcements and updating their policies. The most recent expansion was to small claims in June. And so we have a number of different proceedings. All of our UDs family proceedings, restraining orders, they're all covered. And then the latest expansion was civil harassment and then small claims. So it's been very systematic, and I think we found that some counties are maybe not moving in such a systematic course. So I think that's something to really look at and ask questions in your local courts if that's happening. The next recommendation, number 9, that we wanted to highlight is that there's going to be an amendment of Rule 2.893 of the California Rules of Court, which allows judges to qualify a non-certified or non-registered individual to be an interpreter on a provisional basis. And it's currently only procedurally allowed in criminal and juvenile courts under Rule 2.893, and that's set to be amended to include civil according to the plan. But until that happens, judges are to follow that procedure in civil cases as well. And I'm not as familiar of how this happens in the criminal courts, but what I've read in the rule is that the interpreter who's seeking to be provisionally qualified has to fill out a form of all of their qualifications. It has to be filed with the court. And then there also has to be a certification from a court administrator stating that there are no available certified or registered interpreters, that they've done a search of all the California interpreters, the regional coordinator, federal interpreters, administrative proceedings interpreters, and they've looked at local agencies and they're saying they can't find anyone. So then it's up to the judge, based on these things on the record, to say whether or not this individual should be provisionally qualified. So that's something that is supposed to be being followed now until there's an official amendment to the court rule. So the next part of this goal is provision of qualified interpreters in court-ordered, court-operated programs, services, or events. So this is a little bit outside of the actual judicial proceeding itself, but it's also being considered a judicial part of the judicial proceedings. And we're talking about things like mediation, required mediation, parenting classes, and this is, the phase for this is to be done by 2020. So beginning immediately as resources are available, but in any event no later than 2020, the courts are to provide qualified court interpreters in all court-ordered, court-operated programs, services, and events to LEP litigants, witnesses, and persons with a significant interest in the case. So I'm sure some of you are familiar in the family law process. There are certain programs that litigants are required to attend. In Los Angeles, it's called Our Children First. It's being offered in English and Spanish, but according to this, it's going to have to be expanded to other languages. There's also required mediation and custody proceedings. And so those are the types of things that this recommendation covers. The next recommendation, number 11, it also instructs judicial officers that when ordering litigants to participate in certain programs, things like batterers treatment or anger management, they have to consider whether that program actually has the language capacity for that person to meaningfully participate. And if they don't, then they have to order an alternative program that's not any more onerous or burdensome to the litigant. So this is also very important so that the litigants can actually participate in the things that they're ordered to do. So I'll hand it over to Janet.
So the next slide, please. So the next slide is the use of technology for providing access in courtroom proceedings, and that's recommendation number 12. And it reads, the use of in-person certified and registered court interpreters is preferred for court proceedings, but courts may consider the use of remote interpreting where it's appropriate for a particular event. Remote interpreting may only be used if it allows LEP court users to fully and meaningfully participate in the proceedings. And I know you guys have some of you probably are wondering what this VRI thing is and what's going to happen with it. And I know for maybe some of you it's actually something very new. But before I go on, is there anybody in the room who has worked as either a telephonic or VRI interpreter? Yeah, there's a couple of them. I was one. So, is there anybody currently, right now, that are using VRI in courtrooms? It could be video arraignments, for example. Great. Great. So, with VRI, it is preferred, in-person interpreting will never be compromised in any way. If we have an interpreter in the courtroom, the interpreter will be interpreting for the person. It is preferred over VRI. VRI is just a kind of a, I wouldn't say a last resort, but it is one of the last resorts on the list. The very last resort is telephonic interpreting. So the courts are planning on using some of the VRI for some of the events. And there is a lot of things that need to happen before VRI is allowed to start taking place in the courts. There's a lot of prerequisites that need to happen. And one of those is equipment. We need to have the proper communication equipment. We need to have communication equipment for the courts, communication equipment for the interpreter, and we have to have proper communication and training to actually know how to use this equipment, or else it's not going to work. So that's one of the goals that we're actually working on. And I actually get to be, I am part of the subcommittee for technology that we're working very diligently on establishing these types of prerequisites for technology. But another very important part of this is the training. As some of you interpreters that actually have experience with telephonic and VRI, it's not easy all the time. In fact, it can be very difficult and it can be very chaotic. And something that must be emphasized and make it a primary thing is that the most important person with VRI is the LEP, because that's the person that's actually receiving the communication, that's the person that's going to be ordered something, that is the person that is seeking the court's help. So that right there is key. And I guess as interpreters, we have to understand, and we have to have the proper training, we have to know how to communicate with the court, have good rapport with the court and saying, you know what, this isn't working, this person is not understanding, the communication is not being facilitated, the attorney needs to have a private conversation with his client. Technology has to have the ability to do that. We cannot compromise these people's rights. It is because of those people that we are here, right? So, with that said, those are the important highlights that I wanted to bring up that the subcommittees are actually working on is the prerequisites, the training, and it's not just the training for interpreters, it's the training for everybody in the VRI event, which is the judges, the clerks, the attorneys, the interpreters. Okay? Let me go over my notes. Another important part of VRI is that VRI, everybody understand what VRI is, right? Video remote interpreting is preferred over telephonic interpreting. We're all, as interpreters, we understand that interpreting is very visual at times. We have to kind of key in on certain cues with the LAP, you know, sometimes a lot of Hispanics talk with their hands, you know, or they do these little things that we kind of understand they're little cues for us that they're not getting what we're saying. Or maybe kind of a lost look in their eye, and then you realize that they're not Spanish, they don't need a Spanish interpreter, they actually speak an indigenous language. So all those little things is very important. And I think we, as the recommendation says, and there's, unfortunately we didn't touch a lot of the recommendations, but I really encourage everybody to read all the recommendations in this section, is that it is very key that the LAP is the one that actually is receiving the message. And sometimes VRI will probably be a resource, but it is, and I have to really put emphasis on it, is that the use of in-person interpreting is preferred over anything. So. Now I'm going to move on, because I can talk forever. Other considerations When appointing interpreters is recommendation 19, effective January 2015, pursuant to Government Code Section 68561, Sections G and F. Judicial officers, in conjunction with court administrative personnel, must ensure that interpreters being appointed are qualified, properly represent the credentials on the record, and have filed with the court their court interpreter's oath. And it says, furthermore, it reads, see recommendation 50, which discusses the training and so on. So I believe everybody, well, most of the courts are already doing that, where you guys, everybody's putting their credentials on the record, correct? Some of them are not? Okay, not yet. So they have until, I'm not really sure when they have until, but that should be probably taking place. So let's move on to the next slide, please. Other considerations when appointing interpreters is recommendation number 23, which is minors will not be appointed to interpret in the proceedings, nor court-ordered or court-operated activities. And I think we all kind of know why. That's important to actually put down as a recommendation so that doesn't happen. And the next slide. And recommendation number 24. Absent exigent circumstances, courts should avoid appointing bilingual court staff to interpret in courtroom proceedings. If the court does appoint staff, he or she must meet all the provisional qualifications and requirements. Currently, CF is actually working on modifying a lot of the INT forms. And we're working on it because, one, they're kind of outdated. So we need to kind of modify and revamp and kind of get them back into the times. But in this recommendations, and if you guys read further the other recommendations, it says that people that are actually going to perform any of these bilingual staff have to meet the qualifications of a non-certified interpreter. And the qualifications for a non-certified interpreter is that they have to have some type of educational background with interpreting. As you guys all know, interpreting is not easy. Being bilingual is not a profession. Interpreting is. And that's something very important that everybody must understand. And I think the courts are working very, very, very hard on this and trying to get this forms revamped and actually getting the right people with the right qualifications to be interpreting. Okay, now I'm going to hand this over to Joann.
Thank you. Okay, so now we're going to move to goal 3, which is also a very meaty goal. It talks about providing language access services at all points of contact outside the judicial proceedings. So these are things like filing counters, self-help when you're requesting forms, getting appointments for classes or mediation, various kiosks, the website, other materials that the court distributes. So this is also a large goal. The timeline for this is by 2020, so hopefully some of the courts are starting to roll this out. But the first recommendation we wanted to highlight is number 25, which states, and this is to be done by this year, 2015, is that the court in each county is to designate a point of contact, an office or a person that will serve as a language access resource for all court users, court staff, and judicial officers. So as advocates, this is very important to us because we always needed a point of contact if we were having problems, if we weren't able to request interpreters. And I think this person can also be useful. Sometimes it is, I think, the interpreter coordinator for the county in Los Angeles, I believe that's who the person is. But I think this person is going to play a very important role in the implementation in each county. The next couple of recommendations that we wanted to highlight are 31 and 32. They kind of work in tandem together. And this talks about courts considering a pilot project to implement the use of remote interpreter services for things like counter assistance, self-help, various workshops and trainings. And so it encourages using video conferencing, things like WebEx or Skype, to really think this through. I think Janet pointed out a lot of the challenges and sort of caution that we have to take in using these remote types of services, but it's something that courts might want to consider for these types of of programs outside of the judicial proceedings. And then the final recommendation, I think we could go to the next slide, is 33. And this also goes to when courts are appointing individuals to work with professionals, other professionals. Judges will often appoint psychologists, mediators, minors counsel, guardians to be involved in the case. And so judicial officers are to also consider language capacity in making these orders and looking at who they want to appoint. And especially if there are going to be contracts with companies where these individuals are going to come from, that should be a consideration that courts should make when entering into these contracts to make sure that those providers are able to provide appropriate language services to litigants. So now I think we're going to move to goal 4, and I'll hand it back to Janet.
So we have goal 4, which is provide high-quality multilingual translation and signage. And can we go to the next slide, please? Can everybody read that? Hopefully that nobody has that sign on in the courthouse. Are you guys ready for the next slide? If you get one more time, how about that one? I like that one personally. Still way a few more after coffee. And the next slide. How about that one? And the next slide. So, the JC will create a translation committee to develop and organize a translation protocol for JC translations of foreign written materials and audiovisual tools. The committee should collaborate with interpreter organizations and courts to develop legal glossaries in all certified languages, taking into account regional differences. To maintain consistency in the translation of legal terms, the committee's responsibility will also include identifying qualifications for translators and the prioritization, coordination, and oversight of translations of material. The qualifications of translators should include a requirement to have a court or legal specialization and be accredited by the ATA, or have been determined qualified to provide translations based on experience, education, and references. Once the JC's translation protocol is established, individual courts should establish similar quality control and translation procedures for local forms, informational materials, recording, and videos aimed at providing information to the public. The local court website information should use similar qualified translators. Courts are encouraged to partner with local community organizations to accomplish this recommendation. And this recommendation should take place during phase 1. And so I think those slides at the beginning kind of explain why this is very necessary. There is no uniformity throughout the whole state, and that's something that should be very important, especially with translations, especially where you have Google Translate translating a lot of these court signs, and people are just getting lost, just like in the first one. I think the first one is actually a Google Translate, which I think is just great. But that totally demonstrates that, and with that I'll pass it on to Joann. Goal 5?
I think that's you.
Oh, is that me?
That's recruitment and training.
Sorry, that is me. So then we move on to the next slide, which is expanding high-quality language access through the recruitment and training of language access providers. And this is something, like I mentioned, CF is really working. This is involving with INT parents. Can we go to the next slide, please? Recommendation 43, courts and JCNCF will ensure that all interpreters providing language access services to limited English proficient court users are qualified and competent. Existing standards for qualifications should remain in effect and will be reviewed regularly by the CF. And that's what happened in phase 1, and that is currently happening now. We're actually revising, we're looking into the forms, and we're actually revising them. We're probably going to be adding a few things, and probably going to be removing a few things from those forms. But the qualifications are basically that they have to have some type of educational background in interpreting, and that the forms will probably include a little bit more to it than what currently is, which is basically just that, and maybe involve some type of training where they're either under a certified interpreter or something where the person is shadowing and learning how to interpret. Not just because you go to interpreting school and get a certificate does it mean that you can actually go to a court and actually interpret. It's actually very intimidating, and if you don't have the experience, you might not even know what's going on. So that's one. Next slide, please. Recommendation 47. Courts must ensure that bilingual staff providing information to LEP court users are proficient in the language in which they communicate. All staff designated as bilingual staff by the courts must, at a minimum, meet standards corresponding to the intermediate mid as defined under the American Council of the Teaching of Foreign Language Guidelines. And you guys can find that in Appendix F of the actual plan, which you guys did not get. The existing oral proficient exam available to the JC's Court Language Support Program class unit may be used for a court to establish foreign language proficiency of staff. Courts should not rely on self-evaluation by bilingual staff in determining their language proficiency. And this should be in phase 1. And I think everybody knows the problem with a lot of bilingual staff is that, they just utter a few words and they're classified as bilingual. And a lot of people don't understand that that's, just because you're bilingual, that doesn't mean you can interpret. And nonetheless, just because you utter just a few words doesn't mean that you're bilingual. It takes a lot more, and I think finally, and that's something that's statewide, finally we're going to have to make something that's more uniform throughout the whole state where we're going to be following some guidelines as to who can be considered bilingual staff. And if that person is a bilingual staff, then that person, not to interpret, but can help LEP people at counters, giving out information, maybe self-help, whatever. But there has to be some type of guidelines to establish who can be bilingual and who is not bilingual.
Okay, so now we'll move on to goal 6, which is the next slide, and this is on training. Training the judicial branch on all of this. So this is also a very big goal because you can have really great policies, but if people don't know about them, or they don't know how to implement them, or you have an LEP court user asking for an interpreter, and the clerks don't know, or the judges don't know, or they don't recognize that individuals need interpreters, or any kind of language service, then it sort of renders the whole plan useless. So this is a huge goal, and I'm hoping that it's already being rolled out in some of your courts, and the interpreter community is involved in providing some of these trainings, because the goal that we wanted to highlight, number 50, talks about judicial officers, including temporary judges, court administrators, and court staff receiving training regarding the plan, all the policies and procedures that may be local to your courts. And they should include things like how to work with interpreters. It talks about interpreter fatigue and ethics, the provisional qualification process, all of the things that we were talking about around technology and when to use it, cultural competency. And this is all supposed to be done in phase 1, so that's 2015, it's coming to a close. So I'm really hoping, I don't know, have any of you been involved in these trainings or know of them going on in your courthouses? No? So perhaps we're a little behind. on this recommendation. I know that in Los Angeles we've had some issues with just, even though there was a great policy, litigants not knowing about it, clerks not knowing how to respond. And so it's something that we are trying to work with our local courts to really move forward. So that was the only one we wanted to highlight in that one, but it is very important. And I'll hand it back to Janet for goal 7.
Question.
I think it is up to that local court to create a process for conducting those trainings, and maybe it is the point of contact that we talked about in one of the previous goals. But I think one of the challenges with this plan is that it is a plan, and it doesn't necessarily mandate certain things to happen by a certain time. And then every county is different in how they are implementing this. So it may be a specific person in one county and somebody else with a different role in another county. So I think if it's something that you want to look into in your county, it's just something you'll have to ask, within the court's leadership, within the administration, to see who is in charge of that and how it's going to be rolled out.
Yes.
I'm just wondering, are there any provisions contemplated about including this training to including lawyers, public defenders, or prosecutors in this training? Repeat the question.
The question is it being contemplated that attorneys, public defenders, and other community members be included in this? And this may actually go to the next goal, which talks about community outreach, but I do think that's a very important point, that there should be some very specific training and outreach done to the community at large, the legal community, the attorneys, and public defenders as well.
What I really meant is just a hands-on working with interpreters in the courtroom.
Mm-hmm.
I don't know if that's a specific recommendation, but I think it's very important. It's something that as advocates, as legal aid advocates, we do try to train our staff, and we offer those trainings also through our local bar associations, but I'm not sure if it's something that's included as part of this, but I think it's very important.
We have a microphone, so if you have a question, raise your hand. I'll come around and bring you the microphone, okay? So right over here. Speak up nice and loud.
Are there any plans, or what are the plans for you to be receiving reports back from the different counties, from the different courts as to what progress is being made and who's in charge and how do you keep constant contact with them?
Well, actually, that's part of goal 8, and we're actually going to, I think, let's finish the goals, and then we can open it up to questions, because I think if we keep going this way, we're just going to get stuck with questions, and we're not going to finish. So the next goal 7 is conduct outreach to communities regarding language access service. Courts, next slide please. Oh, there we go. Courts should strengthen existing relationships to create new relationships with local community-based organizations, including social service providers, legal service organizations, government agencies, and minority bar association to gather feedback to improve court services for LEP court users, and disseminate court information and education to the community. So this plan is not going to work if it's just us in courts, because it's not just us in courts. And as you notice, this whole plan came into existence from an outside organization. So this is extremely important for this plan to be successful. It's actually the outreach. Because if we cannot go out and give the information and get these organizations involved that are fundamental to the court system, then it's not going to work. So training, information, knowledge, the whole system has to be tied in. One cannot work without the other. This whole plan will not work if we don't work together. And with that, I'll go.
So the last goal we're going to talk about, then we're going to get to the questions, because we definitely want to hear your feedback and your input. But the last piece of this is what the Judicial Council is calling monitoring and management. When you see that, you should probably understand enforcement. But of course, judges don't want to use that term because nobody enforces anything against judges, right? They do the enforcing. But I recommended they use the word the enforcement, and I got nixed. But that's what we're really talking about here. Because as the question, I think, so pointedly noted, this thing is not self-executing, right? Except to the extent that the people involved make it work. And frankly, you guys are going to be key to this. But one aspect of this, and required by the language, or the, what are they calling this, the language access plan, is that there will be a complaint process, or complaint form, a standardized complaint form that is uniform across the state, that will then be a process in each county by which in each court by which those complaints can be received. And that's going to cover all of the areas that we've talked about, whether it's identification of need and notification of services, the provision of qualified interpreters in civil, the referral of parties to cases where there are, to services where there are language access is provided, VRI, all of these issues that we've talked about are established by the plan in this excuse me, management system, not enforcement, is going to be the mechanism by which the people are supposed to be held to the standards and the requirements of their plan. So obviously no one is going to be closer to that process and that experience than the interpreters themselves. So I think you guys are going to be very key. And in fact, it is contemplated in the language of the goal that it's not just the parties who are able to file complaints about these issues. It is also court staff and lawyers and other participants. So I hope you will be very much involved in that, because, and I hope that you will also be reaching out to your friends and allies who are part of this language access plan, the folks here and others involved in it. You've got other CFI members, including Janet, who are participating in this, and I hope you will use them as a conduit for making sure that the system does what it says it's going to do. Because look, let's understand that there's been a lot more rhetoric than there has been action in this area. So we're hoping now that now that the courts finally seem to be actually, engaged in this. It's been slow and it's been a long time coming, but it does appear to be happening now, and you guys are going to be key to making it work. So I think now we are ready for the questions and your input, which we really are eager to hear from you.
And also, we're very interested in hearing updates, as we're all on the implementation task force, so we'd like to know what's going on in your courts. Are they going through the priorities? Is the expansion happening? So questions and updates.
I have a question. We have a system that worked in the past when people want to become certified and have to take tests and have to go through all the procedure to be certified. Then when there's a need for other languages to be certified or registered, we have decided to give each court a power in deciding on whom to be qualified. Now we're talking about the learning curves again for each court, and we cannot assume that just because the court designates somebody is qualified, they are qualified. Because the need for each court to be qualified, there has to be a quality control. Who is going to be designated to do that quality control from each court, each county, each places? So I don't understand why that every time that we have a need for new languages to be certified, we have to find new personnel to be designated to be the one who do the qualifying. Why can't we go to a school, an organization that we know that worked for the last 30 years?
I know. I think I'm just.
That's actually a very, very good question. And that's something that CF is actually looking into. I think everybody's familiar with some of the problems with using non-certified interpreters, where the qualifications are really kind of just overlooked. They're really not really paying attention as to what qualifications these non-certifieds have. And then I think the biggest problem is that people that are qualifying these people are people that don't speak that language, and that can be a serious problem. And I think that's something that's actually an issue that is being discussed in CF. And as interpreters, the only thing, as a member of CF, the only thing I do really recommend is that if you guys don't say anything, if you guys don't send letters, don't tell me situations, don't send anything to CF, CF thinks everything's fine. We're not going to be able to solve any problems because there is no problems being presented. And your involvement in CF is very important. CF is the Court Interpreter Advisory Panel. It is basically the organization within the AOC that is charged with actually the certification and registration of interpreters, the use of non-certified interpreters. It has a lot of things that they're working on, but if we don't handle these situations as to, you guys should really reconsider just certifying or using non-certified interpreters with these standards, because these interpreters are not interpreting correctly. They have no training. Or, in some situations that I've seen, they're non-certified for like 20 years and have never taken one interpreting class, and they really don't care to take an interpreting class, but they keep being used. But if you guys do not voice this, send it to CF, this problem is not going to be addressed, because it's just basically just a few interpreters on the CF panel that is just saying to the people, to the court, saying, hey, we have a problem here. These interpreters, they don't follow the ethical guidelines that were established. They don't have to because they're not certified. They don't even get a slap in the hand. And we need to change that. But it really takes all of us to make some change. So I hope I answered your question. I know it's not the answer probably that you were looking for, but I, being a member of CF, cannot help unless I have something to go with these people and say, look, this is the reason why we should need to fix this.
About what is happening and how the implementation is going. But courts are really not very good at gathering data, and that's been a big challenge for the people who are trying to make this happen. And CFI has the CFI table. I encourage you to go by and pick one of these up. We're going to be doing a 1-month campaign from October 13th to November 13th to gather information. You can go to our website and report what's happening in your courts. If you see barriers to language access, we want you to tell us about it. Just as Janet is saying, we can't pull together the information and give the feedback to the implementation task force and to the CIOP without really knowing what's going on out there. So it's very easy to do. You can click on our website, there's a button, and you can report the details of what you observed, and we can synthesize all of that. That's one of the roles that CFI gets to play. So I really encourage you all to do this in a concentrated way in the month of October through mid-November, and then you can continue using it after that. But also just for feedback, CFI is trying to monitor what's happening around the state. It's very difficult, but what we see is courts are all over the map too. Some are going for it full force. They're trying to hire extra interpreters a little bit, and they're trying to do as much as they can and to cover everything. And others are resisting even doing the priority cases. So that's a very general feedback, but it's all over the map.
Hi, thank you very much for your presentation. My name is Patrice, and I'm a California sensitive person. I love the state of California. And I'm curious about your plans to have some impact on federal programs. Because I work in U.S. immigration court, and I can tell you that the priority in U.S. Immigration Court is VRI for ICE detention centers. So that's the primary mode of interpretation, VRI, and that's the direction that we're going in U.S. Immigration Court. And another thing that I wanted you to comment about was what you said earlier about the LEP being central to the process. Well, I can tell you again, from the U.S. immigration point of view, U.S. immigration court point of view, I'm sorry, I'm nervous. I see the process there as being more inquisitorial than informational for the LEP. So what's your impact going to be on federal programs? Because the federal mantra is, hey, we're not California, we're federal. You can say whatever you want about California, but we're not California, we're federal. So that's my question, and I'm sorry, I'm very nervous. I always get nervous.
Well, when you